My name is John Fleming, and I'm a prosecutor in the Nacogdoches County Attorney's Office. This program is intended to provide information to the public about the duties and responsibilities of the County Attorney's Office, including general discussions of laws that the office is obligated and duty-bound to prosecute. We hope through this effort that the viewing public will learn more about its prosecuting attorneys, what they think, what they do. And we hope that this program will enhance the public's understanding of the role of a prosecutor in local law enforcement. This public venue allows for more detailed discussions of what happens in our office. It allows for more detailed conversations and hopefully a more complete understanding of the nature of prosecution. It is our hope that we can introduce various partners in the community who work closely with prosecutors, whether it be peace officers, probation officers, advocates who assist victims of crime, or mental health providers. We hope we can be a voice to help educate the public on the role of a prosecutor. None of the opinions expressed on this show are intended to be or replace legal advice. You should consult an attorney of your choosing if you have or think you have a legal problem. Joining me today on the show is Stephanie Stevens, a prosecutor in the Nacogdoches County Attorney's Office, a veteran of many courtrooms, having practiced for over 20 years prosecuting cases, tried over 200 cases to jury verdicts. The subject that we'll be discussing today are innovative initiatives in prosecution. Stephanie, welcome to the show.
Thank you, John. John, that's a really timely topic for us to be talking about for a number of reasons. First of all, here in the 21st century, we've got to be a little bit more proactive as prosecutors and try to do more than just punish people. There's much more of a movement in our society to try to fix some of the problems that are causing people to break laws. And we try to be responsive to that. Additionally, since we're really dealing with misdemeanors, lesser crimes, it seems a little bit more appropriate in our venue to be problem solving and trying to deter people from committing future crimes instead of just punishing people for their acts.
And that allows the prosecutor to be something more than just a robot, but actually use their training, their experience, some of their judgment, and even their discretion in recommending sentences or for resolution of cases, Stephanie. And it's been in the past, prosecutors, I think, have frequently been ones who simply look at a problem, put together a jail time sentence, for example, not thinking about the next time that there might be an offense. In your experience, have you seen an evolution over the years in prosecution from the 90s when you were prosecuting in Harris County and now, of course, in Nacogdoches County?
Absolutely. And sometimes I'm not sure if it's so much society evolving or if it's me seeing more and maturing a little bit and maybe not being the rapid knee-jerk reaction person I was back then. But I do see more areas for us to try to deter crime, but I see other ways that we also can do some innovative things to work with law enforcement to try to kind of change the way crimes are prosecuted. And one of the things that we've certainly done in our office is working with blood search warrants.
Yes. And I'm glad you introduced that subject, Stephanie. Many people may or may not know that when an individual is placed under arrest for DWI, he or she is given an opportunity to provide a breath or a blood specimen. And for years, up until probably 2009 or 2010, the crime scene of a DWI was controlled in part, at least by the suspect. In other words, if a law enforcement officer wanted a breath or blood specimen, there wasn't a way to compel that breath or blood specimen. So in other words, they were to some degree limited in terms of what they could do to complete the investigation. But it wasn't that long ago that case law came down and the law was interpreted such that a law enforcement officer or a peace officer can make application with a judge for a blood search warrant so that the investigation is more complete.
Sure, and it's not just that something changing in the law so much as it is technology changing too. We've come from a time where to get a search warrant, police officers have to sit down at a typewriter and or handwrite an affidavit and then go find a judge in the middle of the night and go to their home with the search warrant and get it filed. Nowadays with modern technology, the whole process has become so much more streamlined. And here in Nacogdoches County, we've got a really good partnership between not just the county attorney's office, but local law enforcement and our local judiciary, our judges, who are willing to accept that phone call and fax and email, no matter what time of night or day it might be.
Absolutely. And just recently, you mentioned the law a few moments ago, and it's not that the law has changed, but I agree with you that the technology has
Absolutely.
evolved. But I was asked, is it legal to take someone's blood? Well, the judge has to review an affidavit.
Oh, absolutely.
There have to be facts that support that the individual was intoxicated and operating a motor vehicle. In other words, the peace officer, whether it's a trooper or a sheriff's deputy, will have to explain to the judge why it is appropriate for a blood search warrant to issue. And then, of course, if the judge does issue the blood search warrant, then under those circumstances, we can secure the blood. But I do agree with you about the collaboration, Stephanie. We do have judges who are very willing to take those phone calls in the middle of the night, oftentimes when individuals have gotten on the road after having been intoxicated. And at the beginning of this program, because Nacogdoches is now a 24/7 no-refusal county.
That's right. That's right. If somebody refuses to voluntarily give a breath or blood sample to a police officer who believes them to be intoxicated, has probable cause to believe them intoxicated, and has arrested them for that, then that person, that officer, just like any other search warrant, because basically what they're doing is asking the judge for permission to search the person's body, writes out an affidavit swearing out facts why they believe they've got this probable cause to do this. They present it to a judge, and if the judge reads the search warrant and agrees that there's probable cause in there, that he says, go ahead, search their body and take that blood.
Absolutely. And because of the subject matter today is innovative approaches to law enforcement and prosecution, the effort here is to basically identify what has been or had been a problem for years, and that is not having all of the evidence that was available at a crime scene. Now we have more evidence, and probably the most significant piece of evidence most of the time, and that is someone's blood.
Sure, and Johnny, not only does it make prosecution a little bit more simple in a lot of cases, it also lets prosecutors know what tools might later be needed to try to craft maybe a probation or try to craft something to punish this person, but also to keep them from offending again.
Absolutely. And what some people hopefully don't know is that when they're on probation, or when a person is on probation for DWI, Stephanie, one of the conditions, a standard condition, is that that individual cannot consume alcohol.
Absolutely. And for years, you kind of relied on somebody's representation. No, I didn't drink. They'd go to their probation officer, and their probation officer would say, have you been consuming alcohol? Nope, check that off. They might occasionally take a drug test from them, a random drug test, but alcohol gets out of your urine pretty quickly, so unless they've had some alcohol in the past few hours, it's not going to show up. But there are ways now for us to determine whether or not people are consuming alcohol on probation.
Absolutely, and particularly on high-risk DWI cases, we take advantage of a device called the in-home alcohol monitoring device. And this is a device that an individual blows into to provide a breath specimen while they're on probation, sometimes even before they're on probation, depending upon the circumstances. And it's in real time, it's image driven, so that whoever's blowing into it, our office receives, or the probation officer receives, a picture of the individual blowing, and it lets us know whether or not they have consumed alcohol. Now there is a minimum threshold, Stephanie, so that if you're at about a 0.02, which we've talked about what that means on another installment, it will not register. But we have an example here of an in-home alcohol monitoring device. If you can hold that up there for the audience, we can see that it's very discreet, and
Looks like those cell phones we first had 20 years ago.
It looks a lot like that. less cumbersome than those, I might
not quite
add.
as heavy.
But if you give me just a moment, what one does is puts the device in such as this, and then holds it up and blows into the device. And you have to blow hard enough and long enough to register a reading, and that reading is what is sent back to the law enforcement professionals. So we're pleased to have this kind of technology available to us to ensure compliance, because we don't want people's representation to be the only means of confirming whether or not they're abiding by the terms and conditions of probation.
Sure. And quite frankly, some people, not all people, but some people who have DWIs have alcohol addictions. And unfortunately, addicts lie about things like that. You know, it's not uncommon for us to hear people try to mitigate their alcohol use, or in drug cases to try to mitigate their drug use.
And that's a great point, that we would all like to believe that what someone is telling us is the truth. We want to believe in the good of everyone. But the reality is sometimes, particularly those who are going through the judicial system, if they have a problem or an issue and they're not taking care of that issue or problem, they might engage in some masking techniques, engage in some deceitful behavior. And that happens sometimes with our drug cases, Stephanie.
Yes.
Can you speak to that?
Sure. We prosecute a lot of possession of marijuana cases, and unfortunately, a lot of them are young people who've never been in the criminal justice system before. The range of punishment for the lowest Class B possession of marijuana is up to 180 days in jail. But sometimes we're more interested in people abstaining from drug use in the future than we are putting young people with no criminal history in jail. And one way we like to determine whether or not these people are abstaining from drug use is by using hair sample drug tests, or sometimes they're called hair follicle tests.
What's the advantage of a hair sample drug test or hair follicle drug test compared to, say, a urine test?
Oh, the advantage is that a urine test, depending on the drug that's used, may go back a few days, whereas a hair sample test goes back at least 90 days. They also do more of a quantitative testing on that, so you see what the levels actually are. So with some people who come in and say, yeah, I did use marijuana or whatever drug a few weeks ago, you send them out and say, go ahead and take a hair sample test now, and let's get a baseline.
Sure.
And then you come back in a few months and see, is it gone? Has it gone down? Hopefully it hasn't gone up, but it's a much more accurate indicator of recent drug use, and it goes back further. It's also less prone to tampering. There are a lot of substances out there that you can use to supposedly, I don't know if they really work, tamper with your urine samples. I've even heard of people bringing in another person's sample to try to pass a drug test.
Which is a crime, by the way.
Which is a crime to do that. Mm-hmm. But a hair sample test, it's pretty clear. They're pulling the hairs from your head. Mm-hmm. They don't like your hair to be dyed to do it.
Sure.
But if your hair is dyed, they can take body hair from anywhere else on your body.
And someone who may be watching the show says, well, I'll cut my hair very short, and that will inhibit law enforcement's ability to be able to test my hair for the presence of drugs. And more recently, Stephanie, I think that you may recall that in a situation like that, we were able to determine that there's actually fingernail testing that can go on. Is that correct?
There is, and I believe it goes back even further than hair sample tests.
That's correct. That is the advantage, is that with a fingernail, we can go back as much as 6 months. And that's something that we want to be able to do so that we know what we're dealing with. And I think that that's part of the process. Yes, we want to know if we've got continued violations for whatever the individual is on probation for. Maybe it's possession of a controlled substance that the individual didn't have a prescription for. Maybe it is marijuana. Maybe it is a synthetic type of drug. But whatever the case may be, if they're still struggling with that, or if they're still using or they are defiant in terms of using it, we have a means of understanding and knowing what the circumstance is, and then crafting a resolution that hopefully protects the public and any potential victims.
Sure, and that resolution can be anything from extending someone's probation to sanctions, to revoking their probation, to recommending some sort of treatment, whatever we feel like is necessary based on the results we're getting on that case.
Stephanie, we've spent a fair amount of time discussing some of the innovative means and methods prosecutors can use to ensure compliance, but there's also some very basic fundamental steps that can be taken in a prosecutor's office to keep law enforcement and by extension the public safer. Just in the last few days, we've read about officers who have been shot and in some cases killed, murdered, if you will, by individuals who were being served arrest warrants.
Absolutely. I would say the two most dangerous times for police officers are traffic stops because they're walking up to an unknown situation, and when they go to arrest somebody with a warrant, because people don't generally want to go to jail. And when the officer shows up at someone's home to arrest them, they don't know what's going to happen at that point.
Exactly. And as a consequence, it stands to reason that the fewer arrest warrants that an officer has to serve reduces the officer's risk to this moment in time when he or she is at greatest danger.
Absolutely. And John, a longtime employee in your office, Billy Tillis, actually came up with a very simple idea, not a little hard work for her, time-consuming work for her, but a very basic and simple idea to try to control that situation. And it kind of goes back to what you were saying about blood search warrants. We want to control the situation. Instead of the officer going out, stopping somebody on traffic and arresting them, going to their home and arresting them, we wanted to craft a situation where people are being arrested if they have an open warrant in a very controlled environment. And Ms. Tillis came up with the idea of every week we have a docket call with 80 to 100 people who show up on their misdemeanor cases. So every week, Ms. Tillis runs a background search on all of those people to determine whether or not they have open warrants. If they do, we notify the agency that has the warrant for them, and they come over to the courthouse and arrest the person in court. And there are other benefits to that too, because to come to the courtroom, they've got to come through a metal detector and come through security. So we're reasonably certain that we're dealing with somebody who's not armed. We're surrounded by law enforcement. Very seldom, if ever, are there any problems in arresting those people.
Absolutely, and some of those warrants are felony warrants. And
Yes.
if a felony warrant can be served in a controlled environment, such as a courtroom, after having an individual pass through security, we feel like we've reduced and mitigated the risk to both the public and law enforcement. And I do have to thank our office manager, Billy Tillis, for coming up with a very simple solution to a very complex problem. Difficult to measure the success because we don't know when we've avoided an issue. It's had the byproduct of Billy's efforts have been that a lot of people have gone and taken care of their warrants voluntarily.
That's right. Nobody wants to particularly come to court any more than they want to be arrested, but they sure don't want the two combined.
Absolutely.
So I think that, when word of mouth gets around, when people who have a tendency to show up in court learn from the other people who have a tendency to show up in court that, hey, if you have a warrant, they're going to pick you up, they're going to hook you up, they're going to call the agency to come get you, then people tend to think, before my next court setting, I might want to swing by the municipal court and handle this ticket or whatever their problem might be.
Absolutely, and I'd also want to mention, Stephanie, that the Sheriff's Office, Nacogdoches Police Department, our bailiff in the County Court at Law, in particular the constable's office at Precinct 1,
Yes.
have worked very closely with the county attorney's office as well as the county court at law to help get these warrants served, because when those warrants are served, it is a time-consuming matter. We like that it's in a controlled environment, and that's fantastic, but it still involves a trip out to the jail. But Stephanie, this what Ms. Till has put together dovetails with bond forfeitures. Can you kind of explain what that is?
I will, and maybe we better basically start with what's a bond. When a person's arrested, they don't have to stay in jail if they can post a bond. And the bond is just an amount of money that says, I give you this money as my promise that I'll show up in court. Most people don't have $500, $2,000, whatever their bond is lying around. So there are bondsmen out there that you can pay a percentage of your bond, and they post the money on your behalf. Once the case is resolved, everybody gets their money back. It's not tied to the resolution of the case, but once it's over, the money goes back. So most of the people who are charged with misdemeanors are out on bond. They've posted a bond. They're not currently in the county jail. If they don't come to court, two different things happen. First of all, the judge issues a warrant for their arrest for failing to appear in court and forfeits their bond. The second thing that happens is that the county attorney's office institutes a civil lawsuit against the defendant and against the bondsman that says you have forfeited your bond and now we get that money.
What is the advantage to the public of having an effective bond forfeiture program in place?
Oh, there are numerous effects. One of the most basic ones from a prosecutor's standpoint is it gets people to court so their case can be resolved. Regardless of what the resolution is, if people don't show up in court, their cases are never going to be resolved. The other advantage I see is that by instituting this civil suit, making the bondsman liable, now we've kind of shifted the burden to them from law enforcement. Instead of law enforcement having to go out with more of these arrest warrants, taking them off the streets, keeping them from investigating other crimes to arrest people, now we've got somebody else who has a vested interest in this person getting back in custody, getting to court. And that's the bondsman who's going to be out a substantial sum of money if they don't get that person into court or into jail or wherever they need to be.
And what we've seen in the county court at law with a proactive bond forfeiture program is a reduction in the number of people who actually miss court, which I believe, Stephanie, is a function of the bondsmen who have an incentive to get their client to court, reminding them of their court date. It's
the bondsman taking some initiative, a lot of initiative sometimes, and calling and saying, this is your reminder that you have a court date tomorrow. But again, it's word of mouth getting out there. When people hear, well, you know, my friend Susie had a court date and she didn't show up and now she's sitting in jail, I'd better show up when my case is set.
And it does help with law enforcement because we've got fewer fugitives out on the street who have failed to appear in court. And as a consequence, we won't have as many law enforcement officers needing to knock on doors or try to find someone who is essentially on the run. And I would think, Stephanie, that from a bondsman's perspective, there's a greater evaluation of the risk attached to whether or not a bondsman will write a bond on a particular case if, for instance, they were a flight risk. And I think that with respect to our bond forfeiture program, it's been implemented and spearheaded by Keith Bradford. Is that correct? Who is a prosecutor in our office?
Yes, and Mr. Bradford has done an outstanding job of collecting money with that bond forfeiture program. I think you probably know the sum better than I do, but I want to say he's collected.
Mr. Bradford has almost single-handedly, obviously with the help of other departments, Stephanie, but I think that he was the real trigger. Over $160,000 that it's gone into the general revenue for the county. And so one of those innovative efforts that he had to, or that he wanted to take care of, and he did take care of, It was challenging, but he did a good job. But I think the bottom line is that it's probably kept the public safer having that in connection with this. But Stephanie, I know another subject that's important to both of us, and we read about in the news occasionally, certainly within legal circles, and that's specialty courts. What are specialty courts?
Specialty courts are courts that, it's a little trendy now, but they're courts that are designed for a certain segment of the criminal population, I guess you'd say. We see them with drug courts. In some of the cities, they have veteran courts that are specifically directed towards veterans who possibly have PTSD or something that's causing some criminal behavior. But
what's the purpose?
The purpose is to tailor a solution to the situation that is much more tailored towards that specific segment of the defendant population.
So, for instance, if we had a defendant in court who had been in Afghanistan or been in Iraq, came back and allegedly committed a crime, and there was a connection between PTSD and that crime, would a specialty court assist in that circumstance?
Absolutely. And actually, John, we have something that in that particular circumstance, while we don't have a veterans court here, we do have a program that could possibly assist that person. We have a mental health court I guess we're about a year into it now.
Yes, and we developed a mental health court in partnership with the County Court at Law, Burke, or what was once called Burke Center, as well as the Nacogdoches County Probation Department, Stephanie, and the Defense Bar. And the idea was that there were various individuals who were recycling through our court system. And they would go to jail for 30 or 40 days for low-level misdemeanor offenses such as criminal trespass that can be serious. And then they'd go to jail, and then they'd come out and commit the same act again. And I think what we wanted to do with the mental health court is reduce that recidivism by having the individual interact with the judge on a more frequent basis. And that is really the gravamen of a mental health court, is that once an individual is placed on probation, typically they don't have interaction with the judge until it's too late. With a mental health court or a specialty court, such as a veterans court, they come and see the judge in the black robe as often as 2 times a month. The judge is trying to make sure, are you still taking medications if you're prescribed for those medications? Trying to make sure that the individual is following the directions of his or her caseworker. The idea is hopefully to reduce the amount of time in jail and also to protect the public, because we'll have fewer law enforcement contacts. We intend to have a more detailed discussion of mental health courts and specialty courts at another installment. But it is, in my opinion, Stephanie, another way that prosecutors are locally trying to do the right thing. We don't always get it done right, but we're trying to do it right.
We're trying to do it. And John, I feel like we've just barely scratched the surface here today, talking about some of these innovations and programs that we are working hard to get into play at the county attorney's office. But I think we've given people a little bit of an idea of what we do and kind of our roadmap for where we plan on going.